What does that mean? I'm sorry.
Means you're liable for the ticket that you received on March 1 of 2019 for doing work without a permit.
City will proceed with agenda item number 8, case number CT-BPR 2019-00048, Patrick Nedrick at 1470 Northeast 142nd Street, Officer Edme St. Louis.
Sir, please state your full name and street address for the record and your relationship to the property.
Patrick Nedrick, 1470 Northeast 142nd Street, North Miami, Florida, 33161. Property owner.
If I can get my witness
City?
to please state your name for the record.
Code Officer Edme St. Louis.
And Officer St. Louis, on or about March 11th of 2019, did you issue ticket number 12807 to Patrick Nedrick?
Yes.
Can you verify that this is the ticket that you issued?
Yes, it is.
Yeah.
And what is the nature of the violation for which you issued your ticket?
There was a fence installed on the east side of the property.
And is it considered a violation of Section 5-32 of the Buildings Code to complete construction without first obtaining a building permit?
Yes.
How did you find out about the violation?
Upon driving on 142nd Street, doing the typical main thoroughfares, I noticed that the fence was fairly new. And when I contact Building and Zoning to double check to see if there's a permit on file, there was none on file. And also when I checked Eden, there was also no permit on file. So then I proceed with issuing a ticket.
And did you take any photographic evidence to sustain the violation?
Yes, I did.
Can you verify that these two photographs dated March 11th of 2019 were taken by you?
Yes, they were.
Without objection, admitted into evidence.
And what is depicted in the photographs?
The brand new fence that was installed without a permit.
And is installation of fencing the type of work which would require a building permit per the city's code?
Yes, it is.
Did you verify with the Building and Zoning Department that this particular type of work was going to need a permit?
Yes, I did. And they said yes.
And did you perform a search of any records to see whether or not there was a building permit on file on the day and time that you issued your ticket?
Yes, I did. And I also double checked yesterday as well. And as of today, there's still no permit on file.
No further questions, Your Honor.
Mr. Nedrick?
Yes, sir. Did not think I needed a permit. Before and after I spoke to Miss St. Louis, because I was told that one of the reasons to get the permit was because of the putting the fence posts into the ground and to make sure the property line was correct. But the fence is bolted onto a previous wall that is there, and I never changed the property line, and there's nothing that is there's no post into the ground. So I didn't have to dig a hole. The wall was there. There's a 3-foot wall there. There was some ficus that was there before. I cut the ficus down, and I needed privacy. So I constructed a fence onto the pre-existing wall to get some privacy in the backyard.
Anything further? Anything further from the city?
No, Your Honor.
I'm going to deny the appeal. However, I'm going to reduce the fine to $250.
All right, thank you.
city will proceed with agenda item number 9, case number CTDIC 2019-00002, Silverstone Real Estate LLC at 2210 Northeast 124th Street. Officer Shanna Sanders.
Please, sir, state your full name, street address, and your relationship to the property.
My name is Edward Kiesel, and I'm the caretaker of the property.
What does that mean, caretaker?
The people that own the property are not there all the time, so they leave me in charge to take care of the maintenance and some bills that need to be paid on occasion.
This is a property located at 2210 Northeast 124th Street.
That's correct.
And Silverstone Real Estate,
Yes,
is that the owner?
yes,
And they're in the real estate business,
yes.
and they don't have anybody present to come and testify?
No, they live in Brazil, and they leave me in charge. I've been taking care of that property, Your Honor, for 12 years. And when Silverstone Realty took over the property, they asked me if I would be the caretaker, and I've been taking care of it ever since.
Who's Adalberto Batista?
He's the owner of Silverstone Realty.
And he's listed in the property records in the Secretary of State's office as
Yes.
residing at 3349 Northeast 169th Street, North Miami Beach, Florida.
That's correct, but he's not there. He owns a house there as well, and he's not there all the time. So right now he's in Brazil. I see him maybe once every 6-8 months.
Okay. Let me hear from the city.
Do you have any authority from the LLC to appear on their behalf this morning?
I mean, they didn't give me any written consent, but they told me to take care of it.
The city would require a power of attorney for him to appear on behalf of the LLC in this morning's proceedings.
I agree, sir. You have no authority, as far as the city is concerned, to be here representing the property owner. You're not an attorney. You don't have a power of attorney. You say you're the caretaker, but that doesn't authorize you to do anything on behalf of the company. So I am going to I am going to allow the city to present its case, and then if I feel as if I need to know something about the property, then I may ask you questions.
Okay.
But you have no way to bind the corporation to anything because you're not you're not an authorized agent.
Yeah, I wasn't aware of that at the time, and when I went down to the city hall, nobody notified me that I had to have a power of attorney. Since I take care of the place on a regular basis, I thought that would be adequate.
All right. You may or may not be called as a witness, either by the city or by me, but I'm going to let the city proceed, and then we'll see where we go.
Okay.
If I can get you to state your name for the record.
Shanna Sanders.
And Officer Sanders, on or about April 23rd of 2019, did you issue ticket number 12879 to Silverstone Real Estate LLC?
Yes, I did.
Can you verify that this is the ticket that you issued?
Yes, it is.
And what is the nature of the violation for which you issued your ticket?
It's for dumping or disposing of debris into the canal in our waterways.
And is it considered a violation of Section 12-8 of the city's code to dump, dispose, or otherwise place in any canal any trash, debris, garbage, or any other type of waste material?
That is correct.
How did you come upon the violation?
I received a call from Marine Patrol Officer Gene Sosa, who informed me of this violation.
And did you go out to the property to verify the existence of the violation?
I went out to the property and I did verify that the property was freshly cut. I could not have get onto the waterways at that time, but Marine Patrol took pictures for me and gave them to me via telephone of the debris that was in the waterways.
And can you verify that these photographs consisting of 10 photographs dated April 23rd, 2019 are what you relied upon in issuing your ticket?
Yes, that is correct.
I will admit him.
And what is depicted in the photographs?
It shows the front of the property, of course, showing that that the grass was freshly cut, and then about 8 shows with Marine Patrol Officer Gene Sosa displayed as tree cuttings and debris. I'm sorry, grass clippings and cuttings floating in the waterways.
And they were in the waterways directly behind the house?
That is correct.
No further questions, Your Honor.
Sir, I'm going to let you speak as a witness.
Thank you.
Do you deny that there was landscaping thrown into the canal?
Yes, I've been doing this business, Your Honor, for 35 years in North Miami. I've been doing this property for 12 years. I've never had a complaint or an issue with any landscape or debris. As a matter of fact, I'm an advocate of the ocean and landscape. Last thing I want to do is litter or throw grass. I did not do any illegal dumping or throw any grass into the waterways. I called up Mrs. Saunders and tried to explain to her on the phone that in March and April we have a very high wind velocity. That property is a corner lot. It is the largest property in Keystone Point, and 60% of the backyard is grass, which leaves me about 3 feet of walkway, concrete walkway around the perimeter. When you have a wind that sometimes I'm cutting grass, and I've been doing this for a long time, you can throw your grass, and my machines are commercial machines. They cost me a lot of money, and when I bought my machines, I bought them specifically for mulching grass so that I can put the grass back into the grass without having. This time of year, I was also kind of surprised because the grass doesn't really grow that much. And I face all my cuttings away from the waterway deliberately so no grass will get into the waterway at all. But when you have a wind coming from a certain direction, and I've had this happen in pools as well as other areas, and customers complain to me, I simply explain to them, look, I push my grass one way, and sometimes that grass on a high windy day will lift that grass up, and you're going to get particles of grass into the pool or into the waterway, regardless to how hard you try not to.
Were you doing any landscaping work on the day that the ticket was issued?
No, all I was doing was cutting the grass, and I do all the maintenance myself.
But you were there that day?
Yes, and I have a video that will show you in a residential neighborhood in Keystone, not in an open area, and I have pictures that will show you how large this property is and how easily that a wind velocity of 15, 20 miles an hour can get grass debris. And when I saw the pictures, I looked at it and I said, that's really nothing compared to the size of the property. If I was deliberately trying to throw grass into the waterways,
Yeah,
you
I
would
don't know
see.
I don't know that the allegations are that you intentionally did anything.
Right, and I can't help Mother Nature. I do the best I can. I try and do the best work.
Was anybody else in the neighborhood doing landscaping on the day
There's-
in question?
There is, when When I first started this business, Your Honor, there was 3 companies
On
in the
that day,
neighborhood.
in that,
Now there's
on that
3
day-
companies on every block.
well, that's not an answer to my question.
Okay,
My question is, on the day in question, when the ticket was issued,
yes.
was there any other property owner doing any kind of landscaping?
Oh, absolutely. There's constant work going on, people cutting the grass
No,
surfaces.
but on the day in question, when you got your ticket, was
Right.
anybody else doing landscaping?
On that property?
On any property near,
Oh,
within
I
that,
mean,
within that block?
I don't have proof that there was a company doing lawn cuttings, but yeah, there's every day.
On that day?
On that day, yes.
Okay. Let me hear from the city?
Permission to get some rebutting testimony?
Yes, of course.
Officer Sanders, upon your conversation with Marine Patrol Officer Gene Sosa, did he indicate that there was any other properties along the canal that were having an issue with disposal of lawn clippings in the canal?
No, we do not speak of any other property except this one.
So he never had a conversation with you that there was a high wind velocity and that all of the lawns were being upswept and all of their clippings were being tossed into the canal?
No, he did not state that at all.
He identified this particular property as being the property from which the disposal of clippings was occurring.
That is correct.
Upon your inspection of the property, when you came upon the property, did you see any other properties that had their landscaping recently completing, as depicted in the photograph? This property recently had been landscaped. Did you see any other properties in that same condition?
I wasn't focused on any other property, so I can't comfortably say I didn't observe anything, any other lawn cuttings,
No
except that property.
No further questions, Your Honor.
Based on the evidence presented, I am going to deny the appeal, find in favor of the city, and am I allowed to assess costs?
Yes.
And assess cost. Sir, nobody's saying that you did anything intentionally, but I'm convinced that the city has proven its case, and so I am going to deny your appeal. So, thank you.
City will proceed with agenda item number 10, case number CTDIC 2019-00001, Tina Chung at 2070 South Hibiscus Drive. Officer Shanna Sanders.
Tina Chung, 2070 South Hibiscus Drive.
Are you the owner of the property?
Yes.
Do you know what the nature of the violation is?
Yes.
Okay, and sir, what is your name?
Peter Chung.
Okay. City, you may proceed.
If I can get my witness to please state your name for the record.
Shanna Sanders.
And Officer Sanders, on or about April 10th of 2019, did you issue ticket number 12877 to Tina Chung?
Yes, I believe so.
Can you verify that this is the ticket that you issued?
Yes, it is.
And what is the nature of the violation for which you've issued your ticket?
For dumping in or disposing of debris and chemicals into the canals in our waterways.
And is that considered to be a violation of Section 12-8 of the city's code?
Yes, it is.
How did you find out about the violation?
While out on the waterways doing inspections, myself, Code Officer Aaron Barber, and Marine Patrol Officer Guido Andola, we observed some paint that was in the rear of this property, that was coming from the rear of the property. We noticed some contractors doing some work at the property in paint that was coming from the rear of the property.
And were you able to capture any photographic evidence of the violation?
Yes, we did.
Can you verify that this photo array, consisting of 6 photographs dated April 10th of 2019, was taken by you?
Yes, those were taken by myself and Code Officer Aaron Barber.
Is that your property?
Yes.
Admit it.
And what is depicted in the photo array?
You can see some white substance, some paint that's floating in the rear of the property,
And how did you ascertain that the paint came from this property and not neighboring properties?
Clearly, I mean, it's directly in front of that property, and then from the stream of how the water was, it was, I mean, just clearly coming from that property. You can see it right behind the property, and that it was, I don't know how to explain it, but coming directly from it. There was no other properties adjacent to it, whereas it appeared to be coming from the contractors were there doing some work. We saw the paint buckets in the rear of the property, very near the property line, but visibly you can see that it was coming from there.
Okay, so it was evident that contractors were performing paint work on the property on the day and time that you viewed the violation?
Oh, yes, because I've observed that property even before that they were doing work. Didn't know that it was paint, but yes, there was definitely construction work going on there.
No further questions, Your
Let
Honor.
me ask a question. There are two houses on one of the pictures. One is a white two-story residence, appears to be under construction, and then there's another house to the left. Which of the two houses is the one in question?
Not the two-story house. Well, there is construction going on.
Three-story house? Okay.
He's joking, but no, he was saying three-story house. There is construction going on at the corner lot on the two-story house, but the paint came from the single-story house where the boat is. I think it's a boat or something near
Okay.
it.
Yeah, and I see the white, what appears to be some white substance on the water just north of the boat, the white boat. Is that the paint that is alleged to have been dumped into the canal?
I would have to see the pictures again, but yes, I believe so.
Your Honor, to be clear.
No, wait, time out. Unless you have an objection.
No objection.
Okay, you'll get a chance.
Got you.
Okay.
Yes, as I'm looking at the picture, yes, it came from the single-story house where the boat is. It came directly from that property, and it was blowing, not good with direction. I can't think of where we were at that time, but yes, it was coming from that property.
Okay, and this was not a Marine Patrol complaint? This was something that you observed on your own?
This was something that, yes, that I observed my own while out on the waterways. Usually every other week, we go out, usually on Tuesdays and Wednesdays, and just do inspections from the rear of the property. And this was the day that we just happened to be out there.
Okay. Now you have your chance to defend yourself and rebut anything the city has put forward.
Can't rebut anything, but we were not aware that our contractors poured that stuff in the water. It's actually stucco from the inside of the house that they were washing out a bucket and they threw it in the water. When Ms. Sadas told us about it, we were like, we would never do such a thing. We actually thought it came from the next door. We're environmentalists. We've lived in Keystone for over 25 years, and it's not something we would have done.
Yeah.
Importantly, where he threw the stuff was right by my boat, and he got that stuff all over my boat also. We're not using him anymore, and if we would not have willingly done this, and we were shocked when we found out that it happened.
Well, this is one of the most serious violations that I have seen since sitting here. I live on the water myself, and I enjoy the bay and the water being
Absolutely.
clean, and this type of dumping into the waterways, considering that that's really one of the most important assets that we have here in South Florida.
And especially in our neighborhood.
And I would definitely encourage you to pursue any claims that you feel that you may have against this contractor, and I would also urge you to file a formal complaint with the county and have his license revoked, because this is outrageous.
No, I know.
But as
What
the
I saw-
property, as the property owner, you are responsible for the actions of your contractor, so I'm going to deny your appeal and sustain the city's citation. I know that you had nothing to do with it, but as a property owner, you're liable for the actions of your contractor, so,
Understood.
make sure that the contractor,
He's been fired, and I know what to do next.
that the county knows about this,
Uh-huh.
and pursue your legal remedies against him for the pain, the suffering, and the financial expense that you're incurring.
Okay,
Okay, thank you.
thank you.
City will proceed with agenda item number 11, case number ATFPW 2019-0002, Gabriel Granier Fidalgo at 12927 Banyan Road, Officer Michael Fuentes.
Ma'am, please state your full name and address for the record.
Mylene Garcia, 12927 Banyan Road.
What's your relationship to the property?
I live there with Gabriel Fidalgo, my partner for 12 years.
Okay. You're a tenant?
No.
You're not the owner?
Yeah, I guess I'm his tenant.
Okay. All right, I'm gonna let you appear without a power of attorney, so I'll let the city present.
If I can get my witness to please state your name for the record.
Michael Fuentes, North Miami Animal Control Officer.
And Officer Fuentes, on or about February 5th of 2019, did you issue ticket number 12657 to Gabriel Granier Fidalgo?
I did.
Can you verify that this is the ticket that you issued?
Yes, that's it.
And what is the nature of the violation for which you issued your ticket?
The nature of the violation is having farm animals within the city limits. She had chickens on her property.
And is it considered a violation of Section 4-11 of the city's code to keep any fowl, poultry, or wild animals in the city?
That's correct.
How did you find out about the violation?
There were several complaints, and when I investigated there, I observed.
And what did you find upon your investigation?
There were 6 large chickens back there with coops.
And did you take any photographic evidence to confirm this?
Yes, I did.
Can you verify that this photo array, consisting of 3 photographs dated February 5th, 2019, were taken by you?
Yes, those are them.
And what is depicted in the photographs?
Like I said, there was coops built for the chickens, and there are 6 chickens.
Did you show the photographs to the property owner?
Yes.
Okay, they're admitted. Okay, proceed.
And, I'm sorry, what was depicted in the photographs?
Depicted in the photographs were the chicken coops with 6 chickens in the yard.
And did you have any conversations with the property owner, letting them know that this was prohibited in the city and requiring him to remove the fowl?
I don't recall. I think afterwards I did have a conversation.
And to date, are those chickens still there?
No, I believe the coops are still there, but the chickens are gone.
Okay. And the photographs that were entered into evidence, that is the conditions that you witnessed on the day and time that you issued your citation?
That's correct.
No further questions, Your Honor.
Ma'am?
Yes, there's 5 chickens that were bigger already and 1 that is very small. In particular, that would be my the pet that I have that is considered my companion because I suffer anxiety and depression since 2017, and I've been under medication, and they were for the purpose of my therapy. I was in several times in contact with Officer Fuentes, and I believe the complaints that he is talking about were issued by the neighbor on the back of the house because of my dog was barking a lot because he had complained to us about it, and we had explained to the neighbor that the dog was barking a lot because we had a bigger dog that was removed from the house and given to a breeder. And my dog lost his companion, so he would scream when we get out of the house, but that will only last for a couple minutes. But the chickens were there for the purpose of my therapy, and I have a letter from my doctor, if you want to see it, stating that they were my companions for my therapy, and that's why we used them. We didn't know that I couldn't have chickens, and the issue that there were a couple of them is because when you buy them, they suggest that you buy a couple of them because you don't know if they're gonna die. So I was able to keep them all alive, and that's why there were 6 of them.
Okay, so there were 6, now there's 1.
There's none right now because I was in contact with Mr. Fuentes all the time, and I asked him how much time I had to remove the chickens because I needed to look for a safe place, because if not, that would have caused me to have a breakdown because I've been caring for them for a while
Okay.
now. So I removed them, and then he kept calling and he kept coming to the house and asking me to remove 1 chicken coop that I had, and I said that was not illegal, that the chickens were not there anymore, and he stated that that would be his indications that I will bring them back, and I said that I will come here to explain myself. They're not in the house, and I removed the chicken coop from the house.
Okay. City, you want to respond?
Do you want to see the letter? And I have told him on the phone that I suffer from anxiety and depression when he went to my house with something that indicated that he was going to remove my dog. My mom was there, and my mom told me he rolled his eyes when he heard that I had this condition.
Okay.
And I found that very not, nice, because a lot of people suffer from this, and it's not hard. It's very hard to come here and do all of this. It gives me a lot of
I know
problems.
it's very stressful. I understand. Would you like to sit down or have some water while I review the letter?
No, I'm
Okay.
fine.
Okay. I've reviewed the letter. I've looked at the photographs. I've listened to testimony. City, any final statements, any comments about the letter?
The city has reviewed the letter, and the city does understand that the appellant, her need to have an emotional support animal. Unfortunately, this is not one that is allowed within our city limits. We are reassured by the fact that she's removed the chickens, and it's our hope and desire that she would find an emotional support animal that is allowed within the city. And I personally, I understand, I have my own little emotional support chihuahua, so.
We went to these animals because I tried some other things and it didn't work.
Okay. Here's what I'm going to do. I don't have the authority vested on my office to rule on matters of ADA as presented by the appellant. It is reasonable to assume, and I accept her testimony, that this was a support animal needed by her, confirmed by the doctor or the medical provider. She didn't know that this was illegal. The city enforces this code section regardless. There may be an opportunity for you and the city to work something out, perhaps another animal, perhaps other conditions. Based on everything that I've heard, I will dismiss I will affirm the appeal, dismiss the ticket, and encourage the city attorney's office to work with the property owner to see if there's some other way that we can provide her with the comfort and care that she needs.
Thank you.
Thank you, Your Honor. The city will proceed with agenda item number 12, case number ATANL 2019-00014, Leonie Orlis at 410 Northwest 129th Street, Officer Michael Fuentes.
Husky.
Ma'am, please state your full name and address for the record.
Thank you. Can I have one translator?
Speak up, please.
One Creole.
You need a Creole interpreter?
Yes.
We have one right behind you.
Yeah, okay.
Please state your full name
Leonie Aurelis,
Léonil Aurelius.
and your street address.
Adresse.
410 Nord-Ouest, 129 Street, Miami, Florida, 33 168.
You're the owner of the property?
Yes.
So, yes, Server speaking. 410 Northwest 129th Street of Miami, Florida, 33168.
Okay. Do you understand the nature of the violation?
Yes, I understand.
And you decided to appeal the violation?
Yes.
Okay, so we'll let the city proceed.
If I can get my witness to state your name for the record.
Michael Fuentes, City North Miami Animal Control Officer.
And Officer Fuentes, on or about March 21 of 2019, did you issue ticket number 12739 to property owner Leone Orlis and tenant Franklin David Calderon?
That's correct.
Can you verify that this is the ticket that you issued?
Yes, that's the ticket.
Yes. Yes.
And what is the nature of the violation for which you issued the ticket?
The dog was running at large.
And is it considered a violation of section 4-7 of the city's code for animals to run at large?
That's correct.
How did you find out about the violation?
I believe I was passing by and I happened to approach the dog out loose in the middle of the street.
And how did you identify that this dog lived at this property?
Several neighbors had passed by and they told me the dog belonged there, and also when I knocked on the door, the resident came out and said that the dog belonged to them.
And were you able to take any photographs of the animal?
Yes.
Can you verify that this photo array dated March 21, 2019, consisting of 4 photographs, was taken by you?
Yes, those are them.
And what is depicted in the photographs?
The dog was out in the street.
And what type of dog is it?
It's a husky mix.
And is it a requirement of the city's code that the animal be kept within an enclosed area or under the direct control of its owner by a rope, chain, or leash?
That's correct. The dog has to be contained and walked on a leash.
And is it not a further provision of the city's code that any person that owning the animal is strictly responsible for compliance of this section, and that it's no defense to a violation that a person did not personally allow or permit the animal to be at large or roam in the city?
I'm sorry, can you repeat the question?
Is it not, is it a provision of the city's code that any person who owns, possess, or have custody of an animal is strictly responsible for compliance with the code, and that it is no defense to a citation or a violation ticket that the person did not personally allow or permit the animal to be at large or roam in the city?
Yes.
Did you have any further conversations with the dog's owner?
I believe so. I just don't recall at this moment, but I did.
But he did claim the animal on the day and time that you issued the ticket
That's correct.
and returned the dog to the property.
Yes, that's correct.
No further questions, Your Honor.
Ma'am, your turn.
May I speak?
Yes.
Monsieur Met Kaila,
I am the homeowner.
Mete loué Kaila,
I rented the home
yon Latino,
to a Latino.
il pa dim li te gen chien.
He did not tell me that he had a dog.
Le yon entre nan Kaila,
When they entered the home,
apre 2 semaines man wè gon chien kap entre nan Kaila.
after 2 weeks, I saw that there was a dog entering the home.
Mwen di yo mpa gen kontra chien nan Kaila parce kontra mnen pa gen chien la den.
I told him I do not have a contract for a dog because my contract does not permit for a dog.
Mwen di yo si pou chien ret nan Kaila, fò yo montre certificat ke chien ale kay dokter, chien gen assurance, chien gen tout bagay.
I told them in order for them to keep the dog at the home, they have to show me proof that the dog goes to the vet, that the dog has paperwork, and the dog is legal.
Ok, yo pa jom fè sa, e chak jou ap ese intimide m.
They never did so, and every day they were trying to intimidate me.
Paske chak jou chien la gen nan la wi, chien la gen nan backyard mwen, mache pou tout kote.
And the dog was, because the dog was running loose, running all over the place, running all over my backyard, defecating all over the place.
A pati de mwa de janvier, yo komanse pa vle peye m kaye la paske m te pale pou chien.
And starting in January, they began not wanting to pay the rent because I spoke to them about the dog.
Yo peye m mwa sa an reta.
They paid me that month late.
Février yo peye m an reta.
February, they paid me late.
Mars yo peye m an reta.
March, they paid me late.
Avril yo pa peye m du tout.
And April, they did not pay at all.
Avril m komanse ale nan kote pou mette papye pou yo sorti kite kaye la.
In April, I began going to court in order to place papers for them to leave the home.
Kounya la papye a deja nan kote.
Now the
tout
paper
process yo ap fet.
is already in court. The entire process has begun.
Yo pa peye m avril, yo pa peye m mai.
They did not.
Yo toujou nan kala mwa de juin.
They did not pay me April. They did not pay, and here in the month of June, they're still at the home.
Hier matin, yo coupe courant nan kaye la paske yo pa peye courant du tout.
Yesterday morning, they cut the power to the home because they did not pay the electricity at all.
Yo di m si m pa connecte courant y apre le police pou mwen.
I was told that if I do not reconnect the electricity, they're going to call the police on me.
Yo rele police.
They called the police yesterday afternoon.
De police vini,
2 police officers came.
yo ale pa deye kaye mwen yo montre panel la yo di se mot desan courant.
They went behind the home. They showed them the electrical panel and told them that I was the one who turned off the power.
Police lan di mwen kal nan prison pou sa.
The police told me that I could go to jail for that.
All right, we're not here on that.
Police lan mwen de mwen si m gen final notice, mwen montre.
The officer asked me if I had final notice. I showed them.
Montre final notice lan.
I showed the final
E mwen
notice,
di yo pa jam peye courant, yo pa peye rent lan tout.
and I told them that they never paid the electricity, and they also
We're
did
not
pay
going to
the
talk
rent.
about electricity. We're here about a dog running loose on the streets of North Miami in violation of Code Section 4-7. That's what we're here about.
Ok, bon, se pou sa ki fè mwen mande yo kaye la paske yo pa vle pouve m ke chen gen yon certificat e yo
Okay.
pa vle peye kaye la mande yo kaye la sa nan tribunal.
That is why I've asked for the home back, because they refuse to show me papers that the dog has a certificate. They refuse to pay the rent and the electricity. That is why the papers are in the court.
Okay, let me ask the city attorney a couple of questions. Why wouldn't you cite the tenant? Why would you cite the owner of the premises and leave the tenant without a violation when the tenant is the owner of of the animal.
So I believe the ticket was issued to both the tenant and the property owner, holding them jointly liable.
Okay,
So the property owner is charged because obviously as the owner of the property, they are liable for the actions of their tenant and any code of violations that are committed by their tenant. Obviously, we wrote it out jointly to the tenant, because he is the owner of the dog. So we find them both liable
oh, I
for
see.
it.
So the tenant was cited.
Correct.
The tenant is not here.
Correct.
I'm going to the extent that that I'm able to bifurcate, and I'm not letting her off the hook yet, but to the extent that I can bifurcate one ticket from the other ticket, I'm going to find that the tenant is liable. I'm going to deny that portion of the appeal that relates to the tenant and find in favor of the city. Now, having said that, this issue may have come up before in the context of property maintenance, and I remember one case where the city took a dismissal of a matter involving a loose animal because it had nothing to do with the house. This probably was a couple of meetings ago. Explain to me why the property owner is responsible for the actions of a dog that the property owner does not own or control.
So it's the city's position that the code violations run with the land. As the property owner, she inherits those code violations that are committed by the tenant. And it's always the city's recommendation, if you're going to lease or out your property, that you include within your lease provisions any kind of mechanisms to collect back from your tenant any code violations that are assessed on the property. In this particular instance, the tenant committed the code violation. Obviously, the only, while we do find that the tenant is liable for it, the property owner is also liable for the commission of the code violation by the tenant.
Okay, but here's my problem, and I need clarification. This has nothing to do with the property.
The
This
dog
is-
resides at the property, according to the photographic evidence that
Okay,
you have.
all right.
That dog resides at that property.
Okay,
And the
s-
tenant, and the tenant who committed the violation resides at that property. The dog was supposed to have been restrained within the property lines, and it was not. That's the violation.
Okay, so that relates back to the maintenance of the property. Okay, you're not suggesting that if the tenant goes out and robs a bank,
No,
that the property owner is responsible for the actions of the tenant?
absolutely not. It's
Okay.
because if you look at the evidence, the tenant provided his license indicating, yes, this is my dog, this is where I reside, this is where the dog belongs. On this day and time, it was not where it belonged.
Okay, so the nexus is to the property itself,
Correct,
which is owned by
Correct.
the lady.
exactly.
Okay. So, I am going to deny the appeal, find in favor of the city, and assess a $100 fine, which is the fine that is provided for in the code.
Thank you, Your Honor. This concludes all of the ticket appeals on the agenda.
All right, we're done with the ticket appeals. Does anybody need a break?
Your Honor,
Yes.
she needs clarifications. Was the fine $500 or
No, it's
$100?
$100.
For me to pay?
Yes, well, you can go after the tenant and ask the tenant to reimburse you, but you'll need to make a claim against the tenant.
No, they do not speak to me.
There are court fees? Okay, so there's a fee to the city, administrative costs of $100, and the fine is $100, so it's $200 total. And I would encourage you to try to get reimbursed by the tenant pursuant to the terms of your lease.
They're not going to reimburse me. They're not even paying me for anything.
Well, can't help that. Okay.
Where can I pay this?
You'll have to speak to one of the code officers in the back.
Back parler avec un officier qui
Merci.
Thank you.
You're welcome. Does anybody need a break? You're all good? Okay. I'm sorry? Okay. So, we are done with the ticket appeals, and we're going to resume with the other code violations. Does anybody need to take a 5-minute break? No? Everybody wants to go forward? All right, I knew that you would say that, and that's why I brought lunch, so I'm gonna, while some of you eat, while some of you are speaking, I may wanna eat something. Anyway, City, are you ready to proceed with code violations?
Yes, sir.
All right, let's hear, which is the first one?
Item number 15, the case number CESTA 2019-00015, J&L Land Investments. Aaron Barber is the officer. Item number 15.
That's J&L Land Investments. Make your appearances for the property owner.
Yes, good afternoon, Your Honor. Phil Riva on behalf of J&L. I have the members of J&L here with me today.
Spell your name again.
Phil, P-H-I-L, Riva, R-E-V as in Victor, A-H.
Okay. And the property address is what?
1922 Northeast 119 Road. North Miami 33181.
Okay, City, proceed.
Good morning, Aaron Barber, City of North Miami Code Compliance. The violation was issued to the property for violation of Chapter 5, Section 5-30D, and it was for the advertising for short-term rental at the 1922 Northeast 119 Road, residential property. Doing routine inspections, and we do check online for ads, and also responding to some complaints from some of the neighbors. We were able to find an ad on the website Home to Go dated May 22nd, as well as I do have an incident report from North Miami Police Department dated, print date was 5/11/2019, both which show that the property was rented, advertised.
Do you have an exhibit you want to share with the property owner, and then I'll take a look at it?
Yes, I do. I have the ad that was printed up from Home to Go. Show it.
Thank you. Thank you, Your Honor.
Any objection?
Yes, Your Honor, just for the record, insofar as Home to Go is not a website through which a property owner can list a property for rent, this does not speak to the violation in question, which prohibits the advertisement of a short-term rental under 3 months. So on that basis, Your Honor, if what they're attempting to show, what the city is attempting to show, that a violation occurred, then the city would have to show that it was actually advertised through a site where you can actually book it. What Home to Go is it's a parasitic, it's one of those dark websites, it's a European-run site, and it's a search engine for property rentals, whether short-term or long-term. So it functions in much the same way, like, say, for instance, Expedia or Google might function, so that when you search a specific area or a specific property for a specific rental, it will return what it scanned the web at the time in question to show whether there are any rentals on any third-party sites. But through Home to Go itself, you cannot book. It is not an advertisement. And JNL never had any dealings with Home to Go. It's like you get arrested and your mugshot shows up online. You have no control over that. That's not an advertisement. And so, in the absence of evidence that Airbnb or Homes or VRBO or HomeAway or all these other short-term sites, in the absence of evidence that the property was listed on that site, I would submit that this is not evidence supporting the violation in question, which prohibits the advertisement. There was no consent here. This wasn't paid for by my client. It's involuntarily put on their site, and you would still have to go through Airbnb to finalize and confirm the booking. Home to Go is just a way to search and figure out if it's still there. So on that basis, we would object, Your Honor.
City permission to respond?
Yeah, go ahead and address the issue of the Home to Go website and whether property can get on there without the property owner's
Well, city-
knowledge or consent.
City rejects the argument made that, that the city's code only prohibits advertisements, actual advertisements on a short-term rental website. The actual language of the city's code is any advertisement that promotes the occupancy or use of the residential property. So we would reject the argument that it would, because it wasn't on a specific website offered for a specific lease period, that the exhibit can't be entered into evidence. The evidence does speak to the violation because it promotes the occupancy or use of the residential property for the purpose of the rental of the single-family residential property for a period of less than 3 months. It was his own testimony that it searches through the dark web to look for other websites that offer short-term rentals to see if this address is correlated with those websites. So it would promote the use of the property on a short-term rental basis.
All right, I will admit it and give it whatever weight I deem appropriate after I listen to the witnesses as to whether they had anything to do with it or whether they were actually doing it through some other website, or whether they knew or had control over the information gathered by Home to Go. So I'm going to deny the objection and admit the document into evidence.
Thank you, Your Honor. If
Let me see the document first, and then I'll let you speak.
Also, sir, if I may, I also have an incident report from North Miami Police Department, incident number 2019-000-16911, where the officer's narrative notes that they made contact with De La Cruz Guerrero, who advised that she's renting the above listed residence Airbnb on today's date until Wednesday. She advised that she doesn't know the owner. However, the advertisement was put up on Airbnb by Lawrence. This is in the police report that I have as well.
Your Honor, I'm
Okay.
good.
If I can
I'm
have the
sorry.
witness verify that this is the exhibit that she handed over, because they're already marked, that's my
Well,
confusion.
Yeah. We're not going to we're not going to rule on any tenancies, illegal rentals. We're only here on the
That's correct.
advertisement.
And Your Honor, if I may, you'll excuse my ignorance. I'm normally in court. I'm never before a special magistrate. This is my first time, so I know the rules of procedure and evidence are relaxed. I've submitted 2 pre-marked exhibits concerning HomeAway. One of them shows that HomeAway is clearly, if you were to log onto their site now, Homes to Go, excuse me, is a search engine. It says the world's largest rental property search engine. And the second exhibit is an email, which our client, as I'm sure they will testify, submitted to a representative at Homes to Go, and Homes to Go replied detailing what Homes to Go does as far as getting information about rental properties out there on the web. With respect to the police report, in the absence, again, I apologize for my ignorance.
Your objection is hearsay.
Yes, Your Honor.
Okay. All right. I've looked at the documents reflecting home to go and house.
Your Honor, if you actually look at the Homes to Go printout, the actual ad has Airbnb logos on them.
I see that.
Right, so you cannot book the house on Homes to Go unless the Airbnb ad is actually on. At one point, I personally spoke to Aaron Barber on the phone, and
Who's Aaron Barber?
The
That's me, officer. Your Honor.
I personally spoke to her on the phone, and when she made contact with me of a cease and desist, I had already taken care of that. I have an email from Airbnb that was sent as early as yesterday, confirming when the last time that ad was active. So I have that if you want to see it.
Question.
Mm-hmm.
So are you saying that Homes to Go works with Airbnb?
No, Homes to Go does not work
You
with
said that it can't rent unless, you can't rent anything or list anything on Homes Away unless the Airbnb.
Not Home Away, Homes to Go. So what
Homes
Homes to Go does is, if at one point you had an ad, it'll, I guess in the cache, in the images, it'll relist the ad without your permission, without your authority.
But you would have had to have first listed your property on another short-term rental website before it could have
Correct.
access.
I spoke to Aaron.
For rent for shorter than 3 months.
Correct.
Right. So
So you did have that ad, or else Homes to Go would not have the ability to promote this property on its website.
Not at the time in question.
Not at the time that Aaron Barber made contact with me, the ad had already been removed weeks earlier, and I have proof from Airbnb stating that the ad had been taken down on April 3rd, and it has not been active since. And I have that email from Airbnb. Now, I told Erin, and she even explained to me, she goes, I told her, I don't even know what Homes to Go is. And she explained to me, she says, well, that would make sense on why Homes to Go would have a listing with Airbnb logos on it. Like, why would a company be repping another company? It's because I have no control. And it popped back up.
Yeah, but once upon a time, there was an ad on Airbnb for a short-term rental. And that ad was picked up by Homes to Go at some point.
But Your Honor, it's not stating that I cannot list an ad. I have an ad right now on Zillow to rent the house for 6 months, for a year. Homes to Go, it will simulate whatever you want. It'll simulate, if you want to book it for 1 day, 2 days, 3 days, it'll simulate whatever you want. But when you try to confirm that booking, it has to go through Airbnb to do that. And when I had it on Airbnb, it was not for less than 3 months. So what she printed out was a simulation of a site that has no control of being able to book the house.
Show me the Airbnb ad that reflected that the house was being offered for a short-term rental within the permissible time that the city allows.
The ad has been inactive. The ad has been inactive when she contacted me. It had been inactive for like 10 days. In order for me to do that, I would have to reactivate the ad and print it out, which then I would have no defense to you because they would say that the ad comes off and on.
But you just stated that the ad that you originally placed on Airbnb was for a 6-month rental.
I'm allowed.
Did I misunderstand
I'm
you?
allowed. I'm allowed.
MLS.
And on
Okay,
MLS.
but on Airbnb.
That is correct. I'm allowed. I'm
know
allowed to
that.
rent the house for more than 3 months.
And that's what I want to see. I want to see whether or not you were advertising it legally.
Well, Your Honor, I don't, respectfully, I think that would be their burden to come forward and show that if there was an ad and it was definitely available for less than 3 months, then come forward and show us. And the other thing is the violation clearly makes reference to Homes to Go and clearly is dated April 11th, which is already 10 days after we have confirmation from Airbnb, which I have here in another exhibit, that the ad was taken down.
By the way, why is the officer here? Is he a witness?
They're owners of the property. They're
Oh.
part. He's also
Okay.
an officer.
I'm a sergeant
Okay.
with Miami-Dade Police. I
Okay.
explained to Erin that too, and I
Okay.
explained to her that I've even been in contact with the chief of police for North Miami. I personally told her, we're not going to come buy a $1.3 million house with intentions of breaking any kind of laws or any kind of code. That's why we're here. So I explained to her that I had no idea what Homes to Go was, and what she sent us was a printout of a simulation of a 5 or 6 day rental. I have no control of that. I mean, the only thing I have right now is, if you check, is 6 months to a year, and the house is for sale. Our company is called J&L Land Investments, not J&L Short-Term Rentals. Our original, and it still is, plan was to buy the house. It was a distressed owner. We felt like we got it for a good price. The Zestimate on the house is almost 1.8 million. I immediately put a brand new roof on the house, and I put brand new furniture on the house. There were people that were living in the house. I let them stay there for free, and they were trying to sell me their furniture. If I'm trying to do short-term rentals, I would do it with used furniture. If you look at the pictures, I put $40,000 of brand new furniture in the house, and it wasn't with the intent to short-term rental it. That was not why we bought the house.
Your Honor, I just would like to point out, if you permit me, the code points out that where a term is not defined, it's given in its plain language dictionary meaning. I didn't see anywhere in this cited violation, which is 530D, a definition of the word advertisement, but the plain language meaning of it is advertising is a means of communication to promote a product or service, and advertisements are messages paid for by those who purposely publish them, and they are intended to inform or influence people. So that's a Merriam-Webster definition of advertisement. The point being, there has to be an advertiser. There's got to be some sort of consent or contractual relationship, and the violation cites Homes to Go. And as submitted in the exhibits, Homes to Go is not a company. I'm sure you can contact them if you'd like and make an ad on their website, but this was not done with their consent. Now, incidentally, Homes to Go, when at the time that she pulled her screenshot, which they submitted into evidence, Homes to Go, if you were to attempt to book it, they would have to confirm through Airbnb. And so ultimately, it's just a gateway to the ultimate site where the booking can be confirmed or reserved. So I know it's very technical, but if we look at the violation clearly says Homes to Go. It doesn't say Airbnb.
We're okay with the Homes to Go, and the city has already stated that the city's code speaks to promoting the occupancy. So obviously, based off of the testimony of the property owner, he had at one time listed his property on Airbnb, a website that is known for short-term rentals, and that's how Homes to Go got access to this listing and is promoting it. The city's issue is that you're allowed to.
Don't talk over each other. Don't interrupt.
The city's issue is that Homes to Go is advertising your property for an illegal use, one that is a violation of the city's code. So whether you consented to it or not, it cannot continue.
Okay.
It needs to be removed.
It has been removed. It was removed before the time in question. And I object to the idea that you are now bringing up this issue that the Airbnb, that it was at one time on Airbnb.
You brought that up. I
Hold
never
on,
brought that up.
just a minute. I let you speak. Let me speak, please. I object to that idea because the violation, we're here on a notice to appear on a violation which is very limited in scope and in direction. And that violation cites Homes to Go. And as we've pointed out, Homes to Go is not a place. Now, you're saying that it's any advertisement, but you're forgetting the part about advertisement. The word advertisement requires an advertiser. It requires a consent and a contractual relationship. So while I take your point that any advertisement means any advertisement, don't forget about the word advertisement, which requires that there be some sort of consent relationship. The city certainly, I hope, isn't suggesting that if your house, for instance, were caught on Homes to Go, that a simple screenshot of your home being bookable, even though you can't even book it on Homes to Go, through Homes to Go would be enough to constitute a violation.
Sir, I can attest that if my home was being listed for sale on a website without my consent, it would be removed immediately.
And that's what we
that's
did.
what the city's
All
asking
right,
for.
let me see what actions,
That's exactly what we tried to do.
what actions you have taken to have that advertisement removed from Home to Go.
And Your Honor, allow me to just point out again, reiterate, the action we took was before this violation was ever even
Okay.
a violation.
Let me just, because this is your first time here, I wanted you to understand that I have previously ruled that advertisements that are not within the property owner's ability to control or remove, and there's no nexus between the advertising and the property owner, I don't consider that to be a violation. I consider it to be a violation where the property owner, either by affirmatively condoning or consenting to the advertisement, or failing to take action to remove it, that it would be a violation if the property owner failed to take appropriate action. But if Homes to Go, with your client's consent and approval, place this advertisement, or having notice of the advertisement, you fail to take steps to have it removed, then I find that to be a violation. So explain to me, and I have the exhibit in front of me, explain to me what actions, if any, your client took to have that advertisement removed.
I'll let my client.
Right. I personally asked Edgar, who's one of my IT guys, to find out how and why Homes to Go. I didn't even have any idea what it was. The moment Aaron Barber made contact with us, as you can see, April 16th, he sent a very clear email to them to please take it down. And they did take it down. We checked, and it was gone. And we would randomly check, and we stopped finding it. So at some point, I just felt that that it wasn't going to come back up. Well, when we got another notice that it had came back up, we attempted again from our county email, so they can see that we were police officers and that we were serious, and we sent them another notice, which is very clear right here.
Okay, the one I have is from an Edgar Tefel, the first exhibit.
That's correct.
And it's has a date of April 16th. Is that 2019?
That's correct, sir.
Okay, and your violation was April 11th, 2019.
That-
So you did that within approximately 5 days.
Well, no, Your
Well,
Honor,
we-
that- I'm sorry, it was taken down April 3rd, and this is,
Yeah.
this exhibit is confirmation that it was taken down on April 3rd. What happened on April 16th was he reached out, and that was for Homes to Go?
For
What was
Homes
that?
to Go,
For Homes
yeah.
to Go. This is the confirmation from Airbnb, Exhibit I.
That was June 5th.
Okay.
If I may just submit.
So basically, we were already in compliance when we got the cease and desist. We were already in compliance.
May I see that?
I didn't know Homes to Go existed until Aaron Barber made contact with us.
Yes.
We made every attempt to take it off of Homes to Go. Immediately.